The U.S. Constitution was signed on September 17th, 1787. From that moment forward, it became known as the supreme law of the land, as described in Article 6. In Article 6, we find what is referred to as the Supremacy Clause. The Supremacy Clause says that every state and citizen must abide by its laws. The first 10 amendments to the Constitution are known as the Bill of Rights. Written by James Madison on September 25th, 1789, only 2 years later, the Bill of Rights was constructed guaranteeing specific protections not defined by the Constitution, such as personal rights and freedoms, a clear judicial process, the power of the federal government, and the power of states and its citizens. As of 2016, there are currently 27 amendments to the Constitution. Though the other 17 do not have a collective name like the Bill of Rights, they have changed the nation in many ways, such as the 13th Amendment that abolished slavery, or the 15th Amendment that protects voting rights for people of any race or color, and the 19th Amendment, which guaranteed all American women the right to vote. Then there's the 18th and the 21st Amendment, with the latter law repealing the former. The 18th Amendment was for the prohibition of alcohol in the United States. The amendment was put in place to protect American morality from the dangerous effects of alcohol. 13 years later, the 21st Amendment was passed, which simply states, "The 18th article of amendment to the Constitution of the United States is hereby repealed." Probably the most known and recited right that is protected by the Constitution is the freedom of speech. This right has been used to protect everything from satirical media, protests, and criticism of the government. Though freedom of speech is usually the most cited protection, James Madison decided to put "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof" in front of, or abridging the freedom of speech, or the press, or the right of the people to peacefully to assemble and to petition the government for a redress of grievances. In 1983, an Oregonian man, Alfred Smith, was fired from his job. Alfred Smith's employer fired him on grounds of misconduct for using peyote. Alfred Smith claimed that the peyote was an integral part of his Native American religious practices and traditions. Even so, possession of peyote was illegal in Oregon, and no laws were in place to allow exceptions for religious reasons. When Smith applied for unemployment benefits, he was denied for his termination being related to misconduct. This is when Smith decided to turn to the court system. In the Oregon Appeals Court, it was decided that denying Smith unemployment benefits because of his religious use of peyote was unconstitutional and protected by the Free Exercise Clause in the First Amendment. With the Employment Division now being satisfied with the ruling, they chose to appeal to the Oregon Supreme Court. Although this has well proved fruitless for the Employment Division, the Oregon Supreme Court not only agreed with the Oregon Appeals Court, but they also refuted the Employment Division's argument, saying that preserving the financial integrity of the unemployment funds was outweighed by the infringement of Al Smith's First Amendment rights. The Employment Division once again was displeased with the court ruling and appealed to the U.S. Supreme Court, where once again the court agreed with the lower court's rulings. Ultimately, the Supreme Court handed the case back to the Oregon Supreme Court, where they found the existing law to be unconstitutional under the First Amendment and was revised to give exception to religious use of peyote. 3 years after the U.S. Supreme Court case of Employment v. Smith, the 103rd United States Congress introduced the Religious Freedom Restoration Act, where it passed unanimously by the U.S. House and passed 97-3 in the U.S. Senate. After this, it was signed into law by then-President Bill Clinton in 1993. Even though the Religious Freedom Act, or RFRA for short, was passed with general favorability, it was not without its own controversy and scrutiny, which ultimately caused the U.S. Supreme Court to strike it down due to it being unconstitutional. In the book Regulating Religion Case Studies from Around the Globe, James T. Richardson, a university professor, did a study about court cases from 1993 to 1997 that were directly affected by RAFRA. According to the findings published in his case study, there were 2,102 court cases about establishment of religion, and 1,226 cases about the issue of free exercise in religion. Based on Table 33.1 in Richardson's book, it is clear to see what groups most benefited in the courthouses. All of the Native Americans, Muslims, and Jewish court cases combined made up only 13.2% of total court cases, while mainline Protestants alone made up 20.6% of all court cases. Identical results are found when looking at court cases about the free exercise of religion. Once again, the three minority religions combined were only 14.9%, just a little over half of the Protestants' 26.8%. Though these numbers are better understood when compared to the population of each religious group. At the time, Protestants made up 14.7% of all the religious population in the United States, while the three minority groups combined were less than 3%. The population can be used to understand the relative volume of court cases. It does not directly relate to the favorability of winning a court case. Mainline Protestants had the highest amount of success in the court system, with a 68.3% favorability rating, compared to the 46.9% for Native Americans, the 45% for Jewish, and Muslims at 33%. Less than half of the mainline Protestants, 68.3%. In 1997, the Supreme Court ruled the Religious Freedom Restoration Act unconstitutional in the ruling of the City of Bourne versus Flores. The case started when Patrick Flores, a Catholic archbishop, applied for a building permit to expand his church. The city denied his request because the local government prohibited new construction on historical districts, which his church happened to fall under. Patrick Flores then sued the government for infringing on his religious liberties. This court case was litigated all the way to the Supreme Court, where Flores argued it was his constitutional right to modify his church as his own personal property. Supreme Justice Kennedy, who wrote the major opinion of the U.S. Supreme Court, argued that Congress was going beyond its powers given in the 14th Amendment, while Supreme Justice Stevens argued the Religious Freedom Restoration Act was a law respecting an establishment of religion, as said in his concurring opinion. Because the landmark is owned by the Catholic Church, it is claimed that RAFRA gives the owner a federal statutory entitlement to an exemption from the generally applicable neutral civil law. Whether the church would actually prevail under the statute or not, the statute has provided the church with a legal weapon that no atheist or agnostic can obtain. In the end, the U.S. Supreme Court decided the bill created to protect the rights granted by the Exercise Clause in the First Amendment violated the Establishment Clause in the very same amendment. In the years after RAFRA was deemed unconstitutional, many states individually adopted their own versions of the bill. As of May 2016, there are currently 21 states with their own religious freedom bill. However, much like the previous Religious Freedom Restoration Act, these state religious liberty bills seem to be laws that favor a religion rather than protect liberties. In 2015, former Republican presidential candidate and former governor of Louisiana, Bobby Jindal, passed Executive Order BJ 15-8. Executive Order 15-8 made it legal to discriminate against someone because of their sexual orientation if it conflicted with one's religious beliefs. As stated in BJ 15-8, religious belief that marriage is or should be recognized as the union of one man and one woman. Executive Order BJ 15-8 was passed only moments after HB 707 failed to pass in Congress. HB 707, which shared the same name, Marriage and Conscience Order, with Executive Order BJ 158 was also pushed by Bobby Jindal. It wasn't until April 2016 that current Governor John Bell Edward passed Executive Order JBE 2016-11, which in Section 4 rescinds and terminates Executive Order BJ 158. Executive Order BJ 158 is only one of many similar bills that allow the country to legally discriminate against someone for their sexual orientation and their gender identification. It's strange to think that after the Supreme Court deemed RAFRA unconstitutional, multiple states would then put into effect their own versions. As history has shown us before, with slavery, the right to vote, and the prohibition, public opinion has changed on what is lawful and what is morally right. Though the Religious Freedom Restoration Act was originally put in place to protect the right of free exercise for minority religious groups, it has now become a weapon to use to discriminate against another group of people. According to Justice Stevens, the Religious Freedom Restoration Act is unconstitutional, though 21 states say it's okay. What do you think, viewer? Are religious liberty bills constitutional? And do religious liberties matter in America today? Comment below.